What this decision does is essentially further delay former President Trump's federal election subversion case on charges that he conspired to overturn the 2020 election result, actions that culminated in the attack on Congress on January 6, 2021. The case will now return to the trial court, which must first determine which actions Trump took in relation to the 2020 election were official and which were done in his private capacity as a candidate for re-election. The ruling marks the first time that the Supreme Court has declared that former presidents may be shielded from criminal charges in any instance. The majority decision penned by Chief Justice John Roberts says presidents may not be prosecuted for exercising their constitutional powers and were entitled to at least presumptive immunity from prosecution for official actions. But Roberts further contended that presidents enjoyed no immunity for their unofficial acts and that not everything the president did was official, adding that presidents were not above the law. Roberts writes that Trump's efforts, for example, to pressure his Vice President Mike Pence to take particular acts in relation to his official responsibilities when presiding over the certification of the 2020 election results were official acts, and that Trump is at least presumptively immune from prosecution for such conduct. Similarly, the court's conservative majority decides that Trump's efforts to pressure certain actions by the Justice Department in relation to his claims of election fraud were within the remit of official duties and therefore immune from prosecution. A decision not entirely predicted by some experts.
I would anticipate the court opening the door to the possibility that a president could be immune from prosecution for some criminal statutes that infringe on official duties, but not these ones, and that Donald Trump's trial should proceed.
While the subversion case is now unlikely to be heard before November's election.
Given the fact, again, that this is the former president who is going to be the Republican nominee in the general election, some people say it would be inappropriate for the Department of Justice to proceed to trial under those circumstances. And even if the Department of Justice wants to, I am reasonably confident that the former president is going to try to get the courts to prevent it. Okay, go back to the Supreme Court and say, hey, you have to intervene and, put this trial on pause because it violates my rights, it's too much of an intervention into the political system, etc.
Trump took to social media, calling it a big win for the Constitution and for democracy, adding that he was proud to be an American. In her dissent, Justice Ketanji Brown Jackson warned that the majority view may have planted the seeds of absolute power for presidents, while in a separate dissent, Justice Sonia Sotomayor wrote that the court effectively created a law-free zone around the president, upsetting the status quo that had existed since the country's founding, further warning that this new official act's immunity now lies about like a loaded weapon for any president that wishes to place their own interests, their own political survival, or their own financial gain above the interests of the nation. Sherman Briceby's SABC News, New York.